If you've relied on the 2-year rule for a bit of breathing space when a new hire isn't working out, then things are about to change. From January 2027, for small businesses, the first 6 months of employment are about to matter a lot more. Now, in this video, I'm going to tell you what is happening, when it's changing, and what it means practically for you in your business as an employer. I'll be answering those questions that employers have already started to ask. So, what exactly is changing and when? Well, from the 1st of January 2027, the qualifying period for employees to bring a claim of ordinary unfair dismissal will reduce from 2 years down to 6 months. This doesn't apply to dismissals which are based on things like discrimination or raising a disclosure or raising a concern which might be in the public interest. And keeping with the theme of reducing qualifying periods, the right to request written reasons from an employer as to why they have been dismissed is also being changed from 2 years to 6 months as of the 1st of January 2027. And a big change, the one that I think people are perhaps not talking about as much, is that the cap on unfair dismissal awards will be removed, meaning that employers may have to pay out a lot more if they're found to have unfairly dismissed an employee. It's also important to note that this only applies to England, Scotland, and Wales and does not currently apply to Northern Ireland. So, what does this mean for SMEs in practice? Well, it means that employers will have a lot less time to think about whether the employee is fit for work, capable, whether their performance is matching, or whether there's something else that you're not quite happy with. It also means that those 6 month probationary periods, they're a little bit too close to the 6 month time frame. And so decisions really need to start being made beforehand, and monitoring needs to be made beforehand, especially when you consider adding in notice periods on top of that as well. It also means that casual contracts and fixed term contracts will need a lot more care than they did beforehand. Now let's answer some frequently asked questions. Does the new 6 month service rule apply to existing employees, or is it only new starters? Well, from January 2027, anybody who has 6 month service at that time and who has been dismissed as of 1st of January 2027 will be able to claim unfair dismissal. Now, what does that mean in practice? It means that if you were employed either July 2026 or in January 2026, or perhaps you're employed in March 2025, by the time that the 1st of January comes around 2027, you will already have had 6 months service. And so those employees would be entitled to lodge a claim. Doesn't always mean they will win. I mean, judges will still look at the merits of the case. Does the removal of the compensation cap in unfair dismissal claims mean in practice? Well, let's not scaremonger and let's be realistic. For cases of unfair dismissal, employees can only claim loss of earnings. And so if you have an employee or ex-employee who wasn't on a huge salary, then it won't mean too much. What it does mean though is that if you have employees who are on larger salaries, and that includes things like bonuses and pensions and other benefits, then it's possible then you'll be paying out a lot more. It also means that when we're looking at whether or not it's important to settle cases early on, then it's possible that the settlements will be a lot bigger too. Is 6 months still the right time for probation periods? Well, you can still have probation periods for the 6 months, but there are some dangers with that. The dangers being that you may not consider a review until the end of that probation period, and that if you then decide to dismiss, and also if you also have notice periods on top of that 6 month period, then that employee is going to have the qualifying service to bring a claim for unfair dismissal. So the solutions are either to no longer have 6 month probation periods, perhaps to have 3 month probation periods, which you can extend if necessary, or to keep a 6 month probation period, but to have dedicated review points, perhaps at 3 months and perhaps at 5 months, for you to assess whether or not you are still happy with that employee's performance. Can I still dismiss someone if they're not the right fit or if they've got poor performance? The short answer is yes, but how you do that is also important. Let's remember, if someone has less than 6 months service, then they don't have the right to bring a claim. They may still argue, however, that they were dismissed for other reasons, such as discrimination, and in which case they wouldn't need the 6 month service anyway. And let's say they do have 6 months service or more. If they are not performing well, or if they're not fitting into the team, providing you're not discriminating or doing something else, providing you can show your reasons why you need to dismiss, and providing that you have followed a due process, a proper process, then you can still make a dismissal. What you will need to do post 6 months is also to make sure you give written reasons for that dismissal too. How do performance processes need to change? Performance processes need to be more formal. There should be accurate records. There should be conversations which are had with the employee. One of the big mistakes that people make with poor performance is they leave it and leave it and leave it and leave it until it's out of hand. And then they say, I want to dismiss now. So at those very early stages, make sure you've documented any conversations, any supervisions, any one-to-ones, any emails. Make sure you have those documents as to why you think the person isn't performing well. And also make sure you can show where you have supported them or where you have encouraged them to do better in their work too. What changes should small businesses be making now to their contracts and to their policies? Well, there are quite a few policies that need changing in relation to other Employment Rights Act changes, but specifically thinking about unfair dismissal and the change in that qualifying period from 2 years to 6 months, there are a few things that you might want to think about. One of the things is to perhaps change your probation period time. If you have a period of 6 months as your probation period, consider reducing that. If you keep it at 6 months, or even if you don't, put in place a midway checkpoint, or that you may dismiss at any point during that probation period timeframe. It's also important to review your notice periods. I see a lot of contracts where they'll say within the first month it's 1 week notice, and then after that it's 1 month notice. You don't really want that if someone's only been working with you for a short while, specifically if they've been working for less than 6 months. So think about changing that also. And in your policies, make sure you say that you will follow the ACAS code of conduct on disciplinary processes and grievance processes from 6 months onwards. There are a lot of policies and contracts at the moment that say they will not follow the ACAS code of conduct if the employee has less than 2 years service. Can someone make a claim of unfair dismissal if they're dismissed before 6 months, but still within their notice period? The answer is yes, if they are making the claim after 1st of January 2027. And if that notice period tips them over into having 6 months service, then they would be able to bring a claim. An example being, if someone was dismissed when they had 5 months and 3 weeks service, but if they had a week notice period, then after that 1 week notice, then they would be able to lodge a claim because they'd have the qualifying service to do so. If you are a small business, then don't panic, and please don't overcomplicate things. Now is the time to tighten those hiring processes, the probationary processes, those disciplinary processes, having those difficult conversations if necessary, training your managers, and keeping up to date with the employment law updates. On that note, if you would like more help, or if you would like to see more employment law resources, then check out the Breathe website for more information.